Para. The applicant who had attained the majority at the time of filing of this petition has impugned the order of the ad hoc district judge 2 and additional sessions judge Aurangabad passed below Exhibit 22 in SC POSCO number 305/2014 dated 30/11/2018. The brief fact relevant to the facts in issue have been summarized as follows. The applicant was arraigned as an accused of the offences under Section 376 (2) and 342 of the Indian Penal Code, read with Sections 3, 6 and 5 of the Protection of Children from Sexual Offences Act 2012 (POSCO Act). The charges were framed. The witnesses were also examined. The accused did not cross-examine the witnesses as the counsel representing the accused did not attend the case. Subsequently, the lawyer changed. He sought permission to cross-examine the witnesses. The leave was granted. However, instead of cross-examining the witnesses, the applicant raised a plea of juvenility. He claimed that on the date of the alleged incident, he was below 18 years. Therefore, the inquiry may be conducted in that regard and he may be dealt with accordingly. Para. The investigating officer has collected the proof of the date of birth of the applicant from the school where the applicant was admitted to level 1st. The certificate issued by the school was attached to the charge sheet. As per the said entry of the school admission, his date of birth was 1/6/1994. The incident occurred on 28/5/2014. The learned ad hoc district judge and additional sessions judge Aurangabad considered these facts and held that at the time of the alleged incident, the applicant was 19 years, 11 months and 27 days old. Para. The learned additional sessions judge granted the leave to examine the witnesses. The applicant examined the headmistress of the school where he was admitted to level 1st. She produced the extract of the Pravesh Patrak and Nirgam Uttara. The extract of the information about the student recorded at the time of his admission. He also produced the birth certificate issued by the village sarpanch dated 4/7/2001, wherein his date of birth was recorded as 1/6/1994. He also supplied the certificate of the village development officer and the office of the village sarpanch dated 6/8/2019, wherein he certified that in the birth register there was no entry of the birth of the applicant. He would also rely on the ossification test dated 4/7/2014. On the report of ossification test, the opinion was expressed that the approximate age of the applicant was between 17 to 18 years. Therefore, if the benefit of a margin of 2 years is given, he was below 18 years at the time of the alleged incident. Para. In the said case, the requirement of Section 35 of the Indian Evidence Act was discussed. It was observed that Section 35 thus requires the following conditions to be fulfilled before a document is held to be admissible thereunder. It should be in the nature of the entry in any public or official register. It must state a fact in issue or relevant fact. Entry must be made either by a public servant in the discharge of his official duty or by any person in the performance of a duty specially enjoined by the law of the country, and all persons concerned indisputably must have access thereto. It has also been held that in the absence of any other statute operating in the field, Section 35 of the Indian Evidence Act will apply.